Hello everyone, this is a re-recording of the webinar that took place last week for the Seashell Trust to look at the legal issues for disabled children aged 0 to 18 and their families. Unfortunately, the recording of the original webinar didn't save, which is very disappointing, but we are re-recording it to be able to share the key information with everyone. And Sharon's going to put some questions to me as best she can. We won't, of course, have all the questions that were asked last time, which is a shame, but I will be able to give you the key information that I gave across to the webinar last time for disabled children aged 0 to 18. And tomorrow, on the 17th of June, we're doing a second webinar looking at issues for young adults, those aged 18 to 25. To introduce myself, I'm Steve Broach. I'm a barrister at 39 Essex Chambers, and I specialise in cases involving disabled children and young people. And I'm now going to share my screen so that you can see the slides for today's talk. Hopefully you can now see my slides, and I'll bring up the slideshow. And just to say at the beginning that it is important to note that the disclaimer at the bottom of the slide here, that the presentation is for general information. I can't provide any case-specific advice on a webinar, of course. I'd have to be properly instructed to do that. And so what I'm saying today is hopefully useful information, but you can't rely on it in any particular case. So where do you get case-specific advice from? Because clearly some people will be needing that. Well, if you search the term rights in reality and then solicitors, so rights in reality solicitors, that will take you to my blog, and a list of some of the solicitors who specialise in this area is posted there. So to begin just with some basics about what the law is and the difference between law and policy, because many of you will have experienced being told, oh, in our area we don't do that. That may or may not be a lawful statement. It depends if the law requires that thing to be done, because if it does, then the law has to be followed, and law trumps policy. So where do we get the law from? Well, first of all, acts of parliament, like the Children Act 1989 or the Children and Families Act, which sets out the SEN and disability duties. And in basic terms, Parliament can make the law whatever it wants it to be. When Parliament creates law that affects public bodies, it either makes powers or duties. And in the Act of Parliament, if the Act says that the local authority or the clinical commissioning group must or shall do something, that's a duty. They have to do it. Whereas if it says that they may do it, then that's a power, because obviously may implies that they may not do it. They may choose not to do it. So that's a key distinction to keep in mind as I'm going through. If you're looking to understand what the rights are for our children and families, you have to find the duty, because it's the duty that gives rise to a right by requiring something to be done. For example, there's a duty, in normal times at least, to secure or arrange all the provision in children and young people's education, health and care plans, at least the education and health provision. That is an enforceable duty. But other things, as we'll see, are mere powers, which the local authority always has to think about doing, has to consider doing, but don't always have to follow requests for those powers to be exercised. So as well as the Acts of Parliament, which give the broad and key headline duties and powers, we have underneath those secondary legislation, generally in the form of regulations like the SEN and disability regulations, also rules, directions and orders, which are all law as well. They're law that's made by government ministers under the Act of Parliament that they relate to, but anything that's in them that is expressed as a duty equally has to be done as if it was in the Act of Parliament itself. So for example, the usual 20-week timescale for completing EHC plans is a duty that's imposed by the regulations, and it has to be followed. It's not just guidance. So all of that from 1A to C is legislation, things that's made by or under an Act of Parliament. We also have in our common law legal system a significant body of case law, and the judges, when they make their decisions and hand down their judgments, essentially create law by establishing precedents that will bind other judges coming along after them at the same or lower levels. So the High Court, the Court of Appeal, the Supreme Court in particular, their decisions will set precedents that would require the same set of facts to be decided in the same way, but of course the facts are never quite the same. So there's always the possibility of trying to distinguish your case. But we do get some very important legal rules from this body of case law, this common law rules. For example, around fair procedure and fair process. So the whole of the law or the majority of the law on consultation comes from the common law saying that in order to consult fairly, local authorities and other bodies must, for example, do it at an early enough stage. They must give people enough time to respond. They must provide enough information for people to make an intelligent response, and so on. And all of those are principles that are set out in the judgments in the common law, in our common law jurisdiction. Now, where do you find out about all those things? The problem with the common law is that it's not all written down handily in one place, unless someone writes a book about it, and thankfully we have. So we've produced Disabled Children a legal handbook, which is now in its 3rd edition with the Legal Action Group. And in the 2nd chapter of that book, we go through what we think are some of the key common law rules for disabled children, including the rule on fair consultation. And those chapters are available free of charge on the Council for Disabled Children website. So if you search Disabled Children Legal Handbook, you can either buy the hard copy and or the ebook from our publisher's Legal Action Group, or you'll go to the Council for Disabled Children website and you can download the chapters free of charge. So that's the first 2 points of this slide, which are essentially the law, i.e. legislation and case law. The 3rd point of the slide is guidance, and guidance essentially is not law. It's something that a public body would like another public body generally to do, but it doesn't have the force of law. But some guidance is statutory, and what that means is that it is itself issued under an Act of Parliament. So, for example, the SEND Code of Practice is issued under the Children and Families Act. And the Act will tell people what they have to do with the guidance. And the SEND Code is what's called have regard guidance. And that means, as the name suggests, that public bodies have to think about it, they have to consider the guidance, but they don't necessarily have to follow it. Whereas other guidance, like working together to safeguard children, the key guidance on children's social care, is act under guidance. And where a public body has to act under guidance, it means they have to follow it unless they've taken a considered decision that there's good reason not to do so. And in my years of practice, I've never known a public body try to argue that they had a good reason not to follow statutory guidance of that sort. So some statutory guidance gets very close to being law. Other guidance, though, is non-statutory, and that means it's been issued by the Secretary of State or maybe a Royal College or another body as practice guidance or good practice guidance or guidelines they would like people to follow, but there's no statutory requirement for them to do so. Now, the common law might require that sort of guidance to be taken into account as what's called a relevant consideration, but there's certainly no statutory, no legislation that says that they must be taken into account even, and certainly not that they must be followed. So it is important, if you're looking at a guidance document, to see what status it has, and it will normally tell you early on in the document itself whether it's statutory guidance, and if so, which Act of Parliament it's been issued under, and what people have to do with it. So another introductory point that's very important is the principle of judicial review. Judicial review is a process where the High Court reviews the lawfulness of decisions or policies that public bodies have taken or are operating. And as the name suggests, again, it is a review process. So it's not an appeal. You can't go to the High Court on judicial review and say, I've been given 12 hours care a week and I think I need 20 hours care a week. You have to challenge the lawfulness of that decision that you only need 12 hours care a week. And normally you do that by attacking the process and saying the process by which that decision has been taken has been unfair or unlawful. There hasn't been proper consultation if it was a policy issue. You've taken account of an irrelevant factor. You've failed to take account of things that are relevant, and so on. But you can also challenge decisions or policies in substance, i.e. that 12 hours is just not enough care. If you can show either that they are unreasonable, which is a legal standard that's set very high, of course. You'd have to show that no reasonable public body would think that 12 hours care was enough. It was outside the range of reasonable responses for the decision maker. Or increasingly, you'd be saying that it was disproportionate. And proportionality is a standard that comes from EU law and human rights law and requires a more intrusive review by the court, in particular looking at a question of whether a fair balance has been struck between the rights of the people who are complaining about the decision or the policy and any wider interest, for example, saving money. So that concept of fair balance I'm going to come back to as being really important in proportionality challenges, also under the Equality Act, as we'll see in just a moment. Now, what you get if you win a judicial review case is you normally get what's called a quashing order. And a quashing order is where the court quashes or sets aside the decision or the policy, and it's as if it was never taken, and the public body has to go away and think about it again. They could, of course, do the same thing again, although that doesn't happen very often. And if they do, they might be challenged again. There may be another judicial review claim brought. You can get what's called a mandatory order in judicial review, where the court will order the public body to do something. But it will only do that where there's only one lawful option available to the public body, where there's only one thing they could have done that would have been a lawful decision. Which again is quite rare. So usually you'll get what's called a quashing order, and you might get a declaration of what the law requires, and then the public body will go away and make the decision again. And very importantly, legal aid funding is available for judicial review, and it can be obtained for children themselves in the name of the child. And in those cases, the parents will act as litigation friends to bring the claim and give the instructions, but the claim will formally be in the name of the child, and funding will go to the child if they are financially eligible. So there are some issues around that, for example, in terms of getting low-level support, what's called legal help funding. But it's worth exploring in every case whether legal aid might be available to fund the judicial review, not least because legal aid gives you what's called cost protection, which means that if you lose, you're very unlikely to have to pay the other side's costs. It's not a complete shield, but in practice, I've never known a legally aided claimant have to actually pay the other side's costs if they've lost. So that's a really important protection that legal aid gives you, as well as paying your own lawyers, of course. If you can't get legal aid, there are other ways to fund claims. People are increasingly using crowdfunding through the Crowd Justice website in particular. But what I would stress is the need to get advice as quickly as possible, because judicial review is a complex process and you need specialist advice, and you're required to act promptly and bring the claim within, at least within 3 months of the date the grounds of claim arise. Now, so people sometimes say you've got 3 months to bring a judicial review. That's not actually right. In some cases, the court will say that actually this was such an urgent situation, for example, if you were challenging public body's budget, that you needed to bring the claim well within 3 months in order for it to be brought promptly. So the short message is this: get advice as quickly as you can from, for example, one of the solicitors on my Rights in Reality blog. And if you have waited and not got advice, it's still worth exploring. It's possible to extend time, but be aware it may be less likely that your claim can go forward if there's been significant delay. Moving on then to look at issues around discrimination, because in my view, very many of the legal answers to the problems that our families face result or come from the Equality Act and the duties not to discriminate against disabled children. And what the Equality Act did was bring together the various forms of non-discrimination law, various different protected characteristics, and put it all in one place. But there are still specific protections for disabled people. And disability is one of the protected characteristics, of course. And there's a very broad definition in Section 6 of the Equality Act, which will capture almost all of the children that we're thinking about today. It's very unlikely, very unusual in my experience, that there's an argument about whether a child is disabled under the Equality Act. So first of all, the first thing that's prohibited under the Act is direct discrimination. That's the blatant, targeted, you need to leave my shop because you have autism and I don't like kids with autism. Hopefully, that's fairly rare. What we see much more is indirect discrimination, where you've got a policy or a practice that applies to everyone or to a wide group, but which disadvantages disabled children in a way that can't be justified. To take a very topical example, schools putting in place very strict behaviour policies to manage the public health risks around coronavirus, saying that if the child can't abide by these policies and can't behave in accordance with them, they'll be excluded, essentially. That's a policy that applies to all the children in the school. So it's not directly discriminatory, but it's likely to indirectly discriminate against disabled children who have behavioural issues. It will disproportionately adversely affect them compared to their non-disabled peers. And then the question becomes, can the school justify having that policy? Now, of course, they'll point to a very strong legitimate aim, which is preserving people's public health, preserving public health of everyone in the school. But at the same time, the measure has to be proportionate to that aim. It has to strike a fair balance. And it may well be that a policy that's as rigid and strict as I'm describing doesn't strike that fair balance and would be an example of unlawful indirect discrimination. There's also a very important protection around discrimination arising from disability. This is where you're treated less favourably because of something arising in consequence of your disability. And that's often an argument that comes up around school exclusions, where the child is excluded because of their behaviour, but that behaviour arises from their impairment and the interaction with the inaccessible environment. So in those cases, discrimination arising from disability is often the key principle that we're looking at. And importantly, the upper tribunal has held that an exemption from the definition of disability for children or people who have a tendency to physical abuse doesn't apply in these kinds of cases if a child has a diagnosis, for example, of autism, and their behaviour is clearly linked to that diagnosis. So we should not see claims being ruled out because the child has a tendency to physical abuse if they have a recognised impairment. And if there is any issue around that, then legal advice will be needed urgently. Question that's just come in from Sharan saying, can schools put in place a behaviour policy saying that the children aren't allowed to move off their chair? I mean, again, that's a perfect example, I suggest, of something that could well be indirectly discriminatory. It's going to be very difficult for any child to not move off their chair. But for some disabled children, it will be impossible, in effect, to stay in their chair for an entire lesson. And so the question would then be, well, we see why you're trying to do that, because you're trying to prevent infection. But is there a more proportionate means? Is there a means that strikes a more of a fair balance that you can achieve that aim? For example, managing children moving off their chairs with staff assistance and support. And that will then be the question that would have to be decided if a discrimination claim was brought. And so then the final, most important, arguably, aspect of the protections from discrimination is the failure to make reasonable adjustments. I'll come back to that in a moment in the school context because it is so important. Similar question from Sharan that some schools are saying they'll only have key workers children and young people. Well, under the government policy, it's always been the case during the pandemic that children with EHC plans were part of the group of vulnerable children and could attend school, subject to a risk assessment as to where they would be safest, essentially. But now, of course, that's being liberalised still further, and all, as I understand it, reception, year 1 and year 6 children are supposed to be able to go back to school, subject to any local decisions to the contrary. So no, children with EHC plans definitely, and now all children with SEND in the specified years should be allowed to go back to school. And any differential treatment of disabled children would always have to be justified in order to avoid discrimination under the Equality Act. And there's also a very important human right to non-discrimination as well under Article 14 of the European Convention on Human Rights. And I'll look at the European Convention in a moment in a bit more detail. It applies when the issue is within the scope or the ambit of another human right. For example, under Article 8, the right to respect for your private life, which includes your physical and psychological integrity, or your well-being, essentially, and the right to respect for your family life, the connections with your family. And so if a decision is being taken that interferes with those things or that engages those issues and it impacts on you in a discriminatory way, you can bring a claim under Article 14. And in those kinds of cases, you can also look at some of the other key principles from the international human rights instruments that we'll look at in just a moment around children and disabled people, for example, the principle of the child's best interests. We'll come on to all that in just a moment. So, looking at the key human rights instruments that might be relevant to disabled children. First of all, the European Convention on Human Rights, the ECHR. This is part of English law now. That's what the Human Rights Act does, in effect. It incorporates the ECHR into our law through Section 6 of the Act, and it says that public authorities must act in accordance with the majority of the European Convention rights, the ones that appear in the schedule to the Human Rights Act, including Article 8 and Article 14. So you can go to an English court or a Welsh court and say, my human rights have been breached and that is unlawful because of Section 6 of the Human Rights Act. Whereas the UN Convention on the Rights of the Child and the Disability Convention, they haven't been incorporated into English law, but they are legally relevant in at least 3 ways. So, for example, the three examples of where they're relevant are if legislation is unclear or unambiguous in some way, in terms of developing the common law and what the values are that the judges identify there, and in terms of interpreting the European Convention rights. The international conventions play in all of those respects. So, although these are quite technical points, you can use these human rights concerns and human rights instruments, I'd suggest. And if you're being told, oh, we don't have to follow them, that's when you'll need legal advice as to when they are relevant. So what do they say? What are the key rights that we find in the conventions? Well, first of all, Article 23 of the Children's Convention is incredibly important, I would suggest, because it gives a benchmark for the standards that we are supposed to be setting as a society for disabled children. And it talks about children having a right to a full and decent life, disabled children having a full and decent life in conditions which ensure dignity, promote self-reliance, and facilitate the child's active participation in the community. Hugely important set of principles. And describing a right to special care, subject to the available resources of the state at that time, but in this long list of ways, and describing an outcome of the fullest possible social integration and development for the child. Article 19 of the Disability Convention then is perhaps the most important right in that convention. You can argue a lot of them are important, of course, all of them are important, but I think Article 19, and it describes not just the right to independent living, as is often said, but also a right to community inclusion, the rights of all disabled people to live in the community with choices equal to others, and not to be obliged to live in a particular living arrangement. And that right applies just as much to disabled children as it does to disabled adults. Rights to participate, rights to be involved in decisions that affect you, the principle of nothing about us without us, under Article 8 of the European Convention itself, under Article 12 of the Children's Convention, Article 7 of the Disability Convention, which are both about the rights of children to participate in decisions that affect them, very important, and the general principle of participation in the Disability Convention. So decisions that are taken which exclude the views and the voices of disabled children are very likely to be unlawful. And then the principle that's had perhaps the most focus is the principle of the best interests of children. Under Article 3 of the Children's Convention, Article 7 of the Disability Convention, so that in all actions concerning children, very widely, the best interest of the child shall be a primary consideration. And that means that the interests and the rights of children have to be considered first, but they can be outweighed by significant other factors, and that would include cost. But what it means is that as a matter of international law, children have to be a priority in any decision taken that affects them. And that, of course, will include decisions to allocate funding to other areas, if it was a financial decision, because that means there's less money available to support children. How is some of this translated into domestic law? Well, under the Children Act 2004 and the Education Act 2002, there are duties on local authorities, on clinical commissioning groups, and on schools to have regard to the need to safeguard and promote the welfare of children in everything they do. And Lady Hale has been clear in the Supreme Court that safeguarding and promoting welfare are two different things. And it's important that local authorities, clinical commissioning groups, schools focus on both those things, not just keeping children safe, as important as that is, but also promoting their welfare more broadly as well. And then we have, under the Equality Act, a very important duty that's described as the PSED, the Public Sector Equality Duty in Section 149, which requires public bodies to have due regard to a series of specified needs when they're doing anything, when they're carrying out their functions, including the need to eliminate discrimination and advance equality of opportunity. And in order for them to show they've done that, the key case of Bracking tells public bodies they have to have a proper understanding of the impact of the decision on the protected group here, disabled children. And then they've got to specifically think about the needs to eliminate discrimination and advance equality of opportunity. Now, if the proposal at that time isn't consistent with those needs, they can still do it, but they need to recognize, they need to face up to that fact, and they need to explain why they're still going to go ahead and do it anyway. So it's very much a duty that promotes transparency in decision making and promotes a focus on the rights and interests of disabled children. And if you put Section 11 and Section 175, the previous children's welfare duties in the mix as well, and then think about the PSED, I'd suggest that what Parliament's doing is saying disabled children need to be a priority when resources are allocated and other key decisions are taken. So these are the legal tools we need to use to try and make that happen in practice. So moving on now to the Children and Families Act. Under Section 19 of the Children and Families Act, everything that local authorities do in relation to a child or young person with special additional needs must involve consideration of, must have regard to a series of needs. The first three needs are all about participation, very important. But the final need I've emphasised on the slide is the need to support the child or young person, etc., in order to help them achieve the best possible educational and other outcomes. So that's a really key, again, a key marker, statutory marker, that Parliament is saying to local authorities, focus on achieving the best possible outcomes for these children and young people. Don't just aim for what's good enough, aim for the best possible. Of course, possible is an important word there, and you've got to take into account what is possible, what's achievable within existing resources, but you're still aiming for the best. That's the ambition that Parliament has told local authorities they have to have for every child and young person. Some key definitions. So a special educational need under section 21 of the Children and Families Act is a learning difficulty or disability that calls for special educational provision. And special educational provision is an educational or training provision that's additional to or different from that made generally for others of the same age in mainstream schools in England, importantly. So the comparator is with other schools across the country, not just what's going on in that particular local authority. And then very importantly, once healthcare and social care provision has been defined, as you'd expect, provision from the NHS and provision from local authority children's services, the Act says that where that provision educates or trains a child or young person, it's to be treated as special educational provision instead of health or social care. And so that means that you focus on what the provision is doing. If it is in fact educating or training the child or young person, then it becomes educational provision. And that means in practice, it will go in section F of an EHC plan. So in my view, the vast majority of therapy provision should be in section F of a child's plan, because it's educating or training the child or young person. It would only perhaps be if the therapy provision was very strictly health related. So chest physiotherapy, for example, is not actually educating or training the child, it's clearing their chest. Then it's not going in section F, it's going in section G. So we look first at whether the provision is educating or training, and if it is, then it becomes educational provision. That's a very important point that often gets lost. One of the reasons it's important is that you can directly appeal about educational provision and get the tribunal to order changes. Whereas for health or social care provision, the tribunal can only make non-binding recommendations, as we'll discuss a little later. There's also a divide between health and social care provision. So in the leading case, the Haringey case, the court said that there's some children whose health needs are so complex that local authorities are not allowed to meet their needs, and not allowed to provide services, for example, short breaks or old-fashioned respite, because they're not allowed to act as a substitute NHS for children. And so in those cases, the NHS, in the form of the clinical commissioning group, will have sole responsibility for that child's care. And we'll come back to the national framework for children and young people's continuing care in a moment to look at that in more detail. Coming back to schools though, and recognising the vast majority of children with SEND will have their needs met in school primarily or exclusively. Of course, there's a presumption in favour of maintained mainstream schooling, but that can be rebutted if it's not particularly what the family want. And if there is a desire for a special school, then that will have to be respected, subject to some exceptions that we'll see shortly. There's a process for schools described as SEN support, but this is in the Code of Practice, not in the law, as far as I know. It prescribes a 4-part cycle of assessment, planning, delivery and review, all funded via the notional SEN budget for schools, and their possibility of getting top-up funding from the local authority. Now, schools have a very important duty that's often forgotten. It's placed on school governors or academy proprietors, and it's a duty in section 66 of the Children and Families Act to use their best endeavours to ensure that the special educational provision that children and young people need is actually made. And that's all children and young people, those with EHC plans and those without as well. And schools also have the duty to meet medical needs. Now, a question that Sharon put to me was, what about children being excluded from school at the moment because they're deemed to be vulnerable? Well, that may be because a proper risk assessment has been completed, and it's established that actually it's just not safe to have a child with diabetes or common lung problems, sorry, say it more simply, or asthma in the school. But if that assessment hasn't been done carefully, and it isn't an individual assessment and it's based more on a blanket policy, then that may well be a discriminatory and unlawful decision, particularly taking into account the duty the schools have to meet medical needs. Now, I said I come back to the reasonable adjustments duties on schools. I'll do that now. So these are separate duties, of course, to the EHC plan duties that are placed on local authorities. Schools don't have to secure the provision in EHC plans. That's a duty on local authorities. What schools have to do is comply with the Equality Act, and that includes making reasonable adjustments. And the duty to make reasonable adjustments applies to school policies, provisions, criteria, or practices, as they're set out in the Act, PCPs, as they're often referred to by lawyers, and also to the provision of auxiliary aids and services. So you can have to make a reasonable adjustment by providing an auxiliary aid or a service, and that can include people. So it may be another way for disabled children to get the extra staff support they need is through the reasonable adjustments duty on the school, if it would be reasonable for the school to do it. And of course, there's no fixed definition of what is a reasonable adjustment. The school must make any adjustments to its PCPs, its policies, or through providing auxiliary aids and services that it would be reasonable for it to make in order to avoid substantial disadvantage for the disabled child. So you've got to show that the situation before the adjustment is putting the child at a substantial disadvantage. And importantly, the duty is anticipatory. So schools have to anticipate what adjustments might be needed for disabled children generally, not just wait until they are asked. Schools can't charge for making reasonable adjustments, but the cost of making the adjustment is, of course, relevant to whether it's reasonable or not to expect them to do it. And in terms of their physical environment, that isn't covered by the reasonable adjustments duty because schools have to prepare accessibility plans which address physical features of the school. Now, if you think there's been a failure to make reasonable adjustments, your remedy is an appeal to the first-tier tribunal, to the same tribunal that deals with EHCP appeals. So it's the DIS bit of SENDIST, as it used to be known. And if you are appealing to the tribunal, I'd say two things. First of all, do get specialist advice from IBSI or SOS SEN or your SENDIAS service or from a lawyer, because discrimination claims are technical and it's very difficult, I think, for people to make an effective discrimination claim without talking to someone who understands how the Equality Act works and understands what things you have to prove to show there has been discrimination. People use the term discrimination and terms like reasonable adjustments quite loosely, but they have technical meanings in our law, and that needs to be properly understood and set out, pleaded, as we'd say, to make sure you can win a discrimination claim. So do get advice. And secondly, do think about other forms of discrimination, because if there's been a question of a failure to make a reasonable adjustment, there may well have been discrimination arising from disability and or indirect discrimination as well. So it's quite unusual in my experience that it would be appropriate to only put in a reasonable adjustments claim without also thinking about other kinds of claims. School exclusions are often, of course, an issue which give rise to issues around discrimination. Sadly, the rate of exclusion of disabled children is still vastly disproportionate. And that includes children with EHC plans, where the guidance, statutory guidance, says basically don't exclude them. You should have an emergency annual review instead and change the name of the school on the EHC plan. The parents can appeal to the tribunal if necessary against that, rather than the child having a disciplinary punishment, which is what an exclusion is intended to be as a matter of law. So we do need to challenge these decisions. Permanent exclusions can be appealed to an independent review panel, but that panel, as the name suggests, can't order reinstatement. So judicial review might still be the remedy in urgent cases around permanent exclusions, and or you can bring a disability discrimination claim. And I've mentioned already this issue around tendency to physical abuse and the fact that that rule is now not applied to exclude children with autism or other conditions that might lead to challenging behaviour that challenges others, that they still remain disabled and can still bring these claims. Of course, the violence or any other kind of conduct will be relevant to whether or not the treatment was proportionate, which is a very important question, but they can still bring the claim. They're not excluded from the definition of being disabled after Mr. and Mrs. C's case in the upper tribunal. Children, of course, who are out of education, those children of compulsory school age, are entitled to be educated by their local authority. And this is often described as education otherwise than at school, because this is a duty that applies where a child is not getting education for any period by reason of illness, exclusion, or otherwise. And then they must be given such suitable education, which should be full-time unless the child needs less. There's a significant House of Lords case called Tandy that shows that local authorities can't take account of their resources to limit the amount of education that's provided under the Section 19 duty. And by complying with Section 19, local authorities will generally also comply with the human right to education in Article 2 of the first protocol to the European Convention, A2P1, because it's quite a weak right. It just says that no person shall be denied the right to education, which means that no one should be excluded from the education system. As long as you are being educated within the system, then your human rights are being respected. It will be where children are left without education at all that there will likely be a breach of their human rights, as well as a breach of Section 19. And if a child has been without education for a significant period of time, that's definitely a situation where urgent legal advice is required. And the solicitors who work in this area will be very adept at getting legal aid in these cases in the child's name, and if where possible, and in challenging these kinds of failures to provide. And if the child has an EHC plan, of course, it's very straightforward because they just have to do it, or at least they do in normal times. At the moment, as we'll see, the local authority has to use reasonable endeavours to secure the provision. But even then, that means more than do nothing, of course. If the child doesn't have an EHC plan, then you may well be relying on the Section 19 duty and saying, well, you have to make suitable provision for this child. What are you going to do? And judicial review will be the remedy in those cases. In terms of social care, moving to that area now, all disabled children are children in need for the purposes of Section 17 of the Children Act 1989 and the guidance issued under that, Working Together to Safeguard Children, which is the guidance both for children in need and also for children at risk, which can create some issues. But it does very clearly set out duties to assess all children in need, a timescale that's a maximum of 45 working days with an immediate response in urgent cases required. And where a child's been assessed and determined they're going to have services, they must be set out in a child in need plan. Now, the problem with Section 17 of the Children Act and the duty to children in need generally is that it is a general duty. So local authorities must have services for children in need, but they don't have to provide a service to any particular child in need under Section 17. And that's why, at the bottom of the slide here, it's so important that disabled children benefit from the Section 2 duty in the Chronically Sick and Disabled Persons Act 1970. So how does that work? The 1970 Act sets out a long list of service types, including domiciliary care at home, short breaks in the community, in essence, transport to social care services, support with adaptations to the home, holidays, etc., etc. And it tells local authorities they have to decide whether in each case it's necessary to meet the child's needs to provide this service. And the guidance Working Together makes clear that the way they do that, local authorities, is they do an assessment under Section 17 of the child as a child in need. And that gives them the information to then decide whether they have to provide services under Section 2 of the 1970 Act. So it's essentially assess, decide, and then, if yes, provide. The local authority can have eligibility criteria. They can say that there are some needs that are lower level, which we don't think that it's necessary for us to meet, taking into account our resources. That's the bad news from the family perspective. But they can only apply those criteria once they've done a lawful assessment to ascertain what the child's needs are. And once it's accepted that the child does have eligible needs, the good news is there's then an absolute duty to provide a sufficient level of support to meet those needs, whether that's in the form of a service or in the form, more often these days, of direct payments, which must meet the reasonable cost of securing the necessary services. So in every case, the local authority must act in a way that ensures that needs are going to be appropriately met or can be appropriately met in the direct payment context. Short breaks are a particularly important service for parents of disabled children, of course. We've known that for many years. And in 2011, these regulations came into force at the very end of the Aiming High for Disabled Children programme, which imposed specific duties on local authorities to provide short breaks. So Regulation 3 of the Breaks for Carers of Disabled Children regulations tells local authorities to have regard to the need of parent carers to undertake essentially ordinary life activities, as you'll see on the bottom of that slide, studying, caring for other children in the family, leisure activities, so on, running the household. What's not on the slide is work. And the reason for that is the service that supports work is childcare, which is a legally distinct thing from a short break. And the Childcare Act 2006 sets out the duties in that area, including duties to provide childcare to working parents of disabled children up to the age of 18 for the child. And I've written about that on my blog. So if you search rights in reality childcare, you'll get an overview of those duties. So one of the questions Sharon's just posed is, should providers be providing short breaks during the pandemic? And the answer is yes, they should, where it's safe for them to do so. So of course, everything has changed as a result of the pandemic, and we can't ignore that. But equally, certainly public sector providers just to shut up shop and not offer anything is very problematic. Private providers, including charities, are much freer to act as they see fit. But if a particular service isn't open, that doesn't get rid of the local authority's duties. They should offer something else. They should find other ways to meet the eligible needs, unless it's not possible for them to do so. But simply to say, oh, well, your regular setting is closed, that's it, wait till the pandemic's over, seems to me to be highly unlikely to be lawful, because it won't amount to proper discharge of the 1970 Act duty to meet eligible needs if there's been an assessment that shows that the child has a need for that service that's accepted to be necessary for the local authority to meet. But at the moment, we're more in the realm of the general duty to provide short breaks, to have short breaks available. So Regulation 3 sets out the what the short breaks should help achieve. Regulation 4 is then very important. It says that local authorities must provide, so far as reasonably practicable, so again, cost is relevant, a range of services that's sufficient to assist carers to continue to provide care, so that's emergency breaks, or to do so more effectively, so that's more long-term planned breaks, across the range of types of break that you see on the slide. And that all needs to be set out under Regulation 5 in the short break services statement, which must include any eligibility criteria that the local authority are operating for short breaks. Now, there's an issue with overnight breaks because the courts have held that you cannot get accommodation under the 1970 Act, under the CSDPA. So the only way that you can establish a right to overnight breaks is under Section 20 of the Children Act 1989. And the duty in Section 20 kicks in essence, if the family are in crisis, as the courts have held, where the parents are prevented from providing suitable accommodation or care to the child for any reason, which could include their disability-related needs or wider family circumstances. And where children are accommodated under Section 20, they become looked after children, which is the same status that children in care have. But that's because they're away from home and they need additional protections. They are not in care. Parental responsibility doesn't change at all when a child is accommodated under Section 20. It's voluntary accommodation and it can be terminated at any time. Also, there's a modified form of short break status for children who go away from home for fewer nights to only one setting. That's been tweaked, at least during the pandemic, by some regulations that have been quite controversial and been challenged, to extend the length of time you can be in a short break setting for and still come under that modified form of short break status under Regulation 48 of the care planning regulations. But the short point is that it's a good thing, in my view, generally, for disabled children to be either modified or full looked after children when they're going away from home for significant periods because of the vulnerability they have in that situation. Of course, there is a stigma that comes from being a looked after child, unfortunately. It's completely wrong as a matter of law. But I think it's really important that local authorities have full and frank conversations with parents about why being a looked after child can be a good thing and an appropriate thing. And also that it gives you potential rights as a care leaver as well, in quotes. Again, you weren't in care, you're a former relevant child, as the legislation describes, which means you can be entitled to ongoing support up to the age of 25. So people, again, will need advice and not just to assume, oh, I don't want my child to be a looked after child because that means I'm a bad parent. That's not what the law says at all. And any practice, any unlawful practice in that regard needs to be challenged. If you're not in a Section 20 scenario, particularly if the duty doesn't apply in Section 20, subsection 1, because hopefully you're not in actual crisis, then you're probably going back to Section 17 of the Children Act, which, as I've already said, is a general duty. And so the local authority will have to decide rationally and reasonably whether or not to provide you with overnight short breaks as a disabled child. But you can't assert a specific obligation on them to do so. So that's an unfortunate gap in the law, I would suggest. And children who are accommodated under Section 17 don't become looked after children at all, either full or modified form. In terms of parent carers of disabled children, important duties to carry out parent carers needs assessments, PCNAs, introduced at the same time as the Children and Family Act reforms, inserting section 17 ZD, ZE and ZF into the Children Act. Very low bar for these assessments. They should be carried out either because they're asked for or because it looks like one would be necessary. And helpfully, they can be done at the same time as a child in need assessment. They can be combined. And so what you're looking for is a joined up or a holistic assessment process where the disabled child is assessed, the parent or parents are assessed, but also siblings may be entitled to assessment, either as children in need themselves because of the impact on them of their brother or sister's impairment and the inaccessible environments that they face, or because they are young carers, and young carers who are providing care have a right to be assessed and to have support so that they don't have to be young carers. The goal should be that no child is a young carer, so other services and support should be put in place for them. So we're looking for a joined up and holistic whole family approach, unless the parent carers want a separate assessment for any reason, in which case they should be entitled to that. At the end of that process, there isn't a new duty to provide services to parent carers. There is for carers of disabled adults, as I'll be talking about tomorrow in the second webinar in this series. But for parent carers of children, the duty is to take into account the assessment and make a decision. The local authority has to make a decision about whether or not to provide services to them. And that, of course, that decision, in my view, can only be taken rationally if all the assessments have been done and all the appropriate information has been gathered, which is why we need this joined up approach. And I said I'd come back to children with complex health needs and the health social care interface. The National Framework for Children and Young People's Continuing Care is the key guidance document here, which, as I mentioned before, I didn't mention it before, I mentioned it last time, is non-statutory guidance, which is rather astonishing, really. But in my experience, it's treated as if it's statutory guidance and everyone purports to follow it. It's described as being relevant to complex cases, but complexity can include needs around behaviour and communication. So a lot of disabled children might be in the frame for support under the continuing care framework, including those with conditions that wouldn't necessarily always be thought of as health-related needs. If you're interested in whether your child might be eligible for continuing care, there's a pre-assessment checklist you can use to have a look and have a think about that. And the key document probably in every case is the decision support tool, which sets out these 10 domains of need. And the CCG has to look at what level of need the child has in each of those domains and score that. And if the scores are high enough, that indicates they're going to be eligible for continuing care, although there's supposed to be a multidisciplinary assessment process in every case, which uses the decision support tool as part of an assessment, not as the only aspect of it. And this whole process is supposed to be very quick, with a decision in 6 to 8 weeks. And then it suggests the package of care will be led by the clinical commissioning group, although it doesn't say that expressly. But it seems to me that if a child is eligible for continuing care, that's because they have a primary health need. And that means at the very least that the care package should be led by the NHS. And it may be, in my view, that it would be unlawful for the local authority to be providing care to that child. And the local authority's role would then be restricted to the education function. But that isn't always what happens in practice. So moving on then to, I think we're now going to look at the EHC process. Yes, and I'll take the question that's been put to me a little later on because I need to explain the beginnings of that process first. So first of all, how do you get into the frame for an EHC plan? Well, you need to request an Education, Health and Care Needs Assessment in section 36 of the Children and Families Act. And the local authority must carry out that assessment if the child or young person has or may have SCN, which is obviously a low bar, and it may be necessary for special educational provision to be made in accordance with an EHC plan. So it's quite a low threshold at this stage, just a realistic possibility that provision may be needed, educational provision may be needed in accordance with the plan. So very important to emphasise at this stage, we're looking solely at education. Although the plan covers health and social care, we're actually just looking at this stage at whether a plan might be necessary to deliver the educational provision. And that will generally be because of one of two things. Either the child might want to go or need to go to a special school, or the provision in a mainstream school is likely to be significantly expensive, above the £6,000 notional figure that schools have. But that's not in any way an absolute rule. There could be other reasons why it may be necessary. There's a realistic possibility that it might be necessary for provision to be made in accordance with the plan. For example, I had a case once where the provision wasn't particularly expensive, but it was quite complicated and quite intricate, and everyone agreed in that situation it was appropriate for it to be set out in an EHC plan. In every case that an EHC needs assessment is done, advice and information must be obtained under Regulation 6 of the SEND Regs. An extensive list of professionals have to be consulted in every case, including an educational psychologist in every case, and social care need to be asked for advice and information as well. And in my view, a response that says, we don't know this child, is not a lawful response to that request. Given how low the thresholds are for assessment, an assessment should at least be offered in those cases to get the information that's required to give the advice. And then once all that advice has been obtained, the local authority has to take a decision as to whether to issue the EHC plan. And the question then is whether it is necessary at that stage for the special educational provision to be made in accordance with the plan. And that's a matter of judgment for the local authority. But importantly, both those questions about whether or not to assess and whether or not to issue are matters you can appeal to the tribunal. And the vast majority of appeals against refusals to assess are allowed, and local authorities are ordered to carry out assessments. So we really shouldn't see local authorities applying a particularly strict test there at all. It's more likely that a decision not to issue a plan will be upheld if the local authority is satisfied, having done the assessment, that actually it's not necessary because appropriate provision is being made. There was a recent upper tribunal decision showing that even though it upheld a first-tier tribunal decision, that even though at that time the provision was appropriate, there was a risk that in the short term, in the future, it wouldn't be appropriate and that more would be needed. And in that context, it was agreed that an EHC plan was appropriate. So again, it's not a particularly high bar that the law applies. Timescales. Now, this quote from the slide is from the Code of Practice, and it very neatly expresses what the regulations say, which is that the whole process must take no more than 20 weeks, subject to some very limited exceptions. The issue at the moment is that some amendment regulations were passed, which add an exemption, which is that what's called the coronavirus exception applies. And that's a situation where the local authority can say that it's not reasonably practicable to do the step in the required time because of a coronavirus-related reason. And if they can say that on the evidence, then they're allowed to take the step in whatever time is reasonably practicable for them to do so. There's no fixed deadline anymore. And that's a real challenge for families because it does mean that the process can be delayed, but only for a good coronavirus-related reason in that particular case. So, for example, 3/4 of our educational psychologists are currently off sick or shielding and aren't working. There has to be a good evidential basis for saying that we can't do things in the normal time frame. Otherwise, the normal timeframes continue to apply. Importantly, one of the things that's been relaxed is the timescale for complying with tribunal orders as well. So it's not just the early stages of the process, it's everything up to the final stage. If the tribunal orders the local authority to maintain a plan or to amend it, even that timescale is relaxed as well. Now, the regulations have been challenged by a judicial review claim that I'm instructed on, which was issued last week. And so we'll see what the court makes of that. But of course, until the court decides there's anything unlawful with them, then they are law and they can be followed. Local authorities can rely on them. So just to be clear what the key sections of an EHC plan are, Section A is the aspirations, the section that's written by the family, not legally enforceable. So moving on, sections B, C, and D are the educational, health, and care needs. Section E, the outcome section, is really important, but particularly for older young people, which I'll emphasise when I speak on Wednesday. Section F is then the special educational provision, which includes all the deemed educational provision, that which would normally be health or social care, but which educates or trains the child. Section G is the healthcare provision, the additional healthcare provision, which doesn't educate or train. Sections H1 is then the CSDPA social care provision, the stuff that has to be done as a result of assessment. And H2 is any other social care provision. So for children, you want all the provision in H1 to reflect the fact that there's a duty to make it. And then Section I is the placement that has to be named. Not every plan will have a placement in it, because if a child's going to have education at home, then the upper tribunals confirm that Section I can be left blank. It must name a school or institution, and a child's home is not an institution. So a question's come in, which is, Is it lawful to only put funding in a plan and no hours? And the very short answer to that is no, it's not. In fact, funding shouldn't be in the plan at all. The plan should have the provision that's required to meet the needs, which should be appropriately quantified and specified. And it's then, the duty is then on the local authority to secure that, which can include giving another body, most generally a school, the money to do it. But that's a matter for the local authority and the school. What the plan has to set out is the provision that is required to meet the needs, i.e. the kind of service or support, the number of hours, the qualifications of the person delivering it, and so on. So it's very concerning, I would suggest, if instead we're seeing funding amounts put in plans and no hours of support. That's completely the wrong way around, in my view. And then section J is the direct payment, if there's going to be one, the SEN direct payment that might be made, for example, to secure a particular therapy service. And it's more likely at the moment the provision might be made via a direct payment, given schools are offering only a limited amount of support. So section 42 of the Children and Families Act creates the duty on local authorities and CCGs to secure or arrange the specified educational or health provision. Now, this duty in normal times is an absolute duty. There's no best endeavours defence. If it's in a plan in sections F or G, it just has to happen all the time. And if it doesn't, then the courts will make a mandatory order requiring it to be done. But the Secretary of State has used powers under the Coronavirus Act to issue two notices, one covering the month of May and one covering the month of June, which downgrade these duties to duties to use reasonable endeavours to secure or arrange the provision. So the guidance the Secretary of State's issued make clear that local authorities are not allowed to do nothing, and CCGs are not allowed to do nothing. They must do whatever is reasonable, but there will clearly be things that they could provide, but it would be unreasonable in their view to do so for cost or other reasons, and then they don't have to do it. And that in my view is very concerning, because it's quite a low threshold, reasonable endeavours. It's very difficult for a family to challenge a local authority that's doing something on the basis that what they're doing is unreasonable. It doesn't say, for example, that they have to take all practicable steps to secure the provision. The reason for this, in large part, the government has explained, is because of concerns that local authorities will be challenged for not doing the impossible. For example, if a plan said that the child had to be educated in a group of up to 6 children in school and the school was closed, well, the local authority can't make that happen. It seems to me that that's going to be rare that will happen, and rarer is still that families would challenge failures to make impossible provision, if that would ever happen at all. But what we are seeing is many reports of families saying that they can't get the support their child or young person needs when it would be possible to do it. But the local authorities are relying on the fact they've only got to use reasonable endeavours. And so these notices have been challenged as part of the judicial review I mentioned earlier, and we will again see what the court makes of that in due course. So in terms of one of the questions, which was, should schools be following EHC plans and should children be getting one-to-one with their TA during the COVID period? I've just answered that in short, because the answer is yes, they should, as long as, well, schools never have to do what's in the plan, of course. The local authority has to ensure that the plan is followed, or at least has to use its reasonable endeavours at the moment to do so. So unless there's a good reason why the child shouldn't get their one-to-one support, then they should get it by way of the local authority using its reasonable endeavours. Or alternatively, of course, as a reasonable adjustment from the school in terms of auxiliary aids and services, as we talked about before as well. And another question I should have taken already was about timescales in terms of statutory reassessments, although I'll talk about reassessments in a moment. They can be delayed as part of the coronavirus exception if there's a good reason why they can't be finished at the moment. But they can, I would suggest, be done virtually, to pick up another question. And what we're looking for, and what the guidance the Secretary of State has issued calls for, and rightly in my view, is a pragmatic and a flexible approach. And so local authorities shouldn't just be saying, oh, we can't do it, it's too difficult. They should be trying their best to make things happen in the best possible way, including using remote assessment processes or remote delivery of provision, if that's possible as well. And the guidance is very good on giving examples of ways in which provision could be delivered differently during the pandemic, even before the current easing of the restrictions, which should make it more straightforward for full provision to be made than it was, for example, a month ago. So I've mentioned already the notices, just to set them out in a bit more detail here. As I say, the duties have been changed by them until the end of June 2020. And of course, they could go beyond that. The Secretary of State could issue a further notice for July, for August, for September, and so on. Local authorities and CCGs must still use their reasonable endeavours to secure or arrange the provision. So they must do everything reasonable to make it happen, but not everything possible. There will be some things which are possible but unreasonable in terms of being too expensive or too difficult to do. But doing nothing, I say, is not reasonable. At the very least, it's very unlikely to be reasonable in any particular case. It's likely to be something that could be done, even if it's short of the full provision. In terms of duties in relation to placement, Section 39 of the Children and Families Act requires local authorities to name the school or the institution that the family request, unless either it's unsuitable for the child or young person, and that's quite difficult for local authorities and schools to show given the reasonable adjustments duty. Similarly, that it's incompatible with the provision of efficient education for others for the child to go there. Incompatibility is a high bar, taking into account the reasonable adjustments duty. And it's not enough for the school just to say we're full, i.e. we're at roll. They'd have to show that adding an extra child, adding this particular child, would be incompatible with providing efficient education for other children. Or, and this is the most frequent issue, that it will be incompatible with the efficient use of resources for the child to go there, i.e. that it's too expensive. And this is particularly likely to come up where there's a request by the parents for an independent school or a non-maintained school, and the local authority thinks that a maintained school can meet the child's needs because the cost of the maintained school placement is zeroed out. So then the local authority would only have to well, then the local authority would be able to say that the independent school or the non-maintained school is much more expensive because they're only looking at the additional costs that come with the child of the maintained school, like transport or therapy or any other specific costs. And in those situations, what parents will have to do if they appeal to the tribunal against the contents of the plan, because of sections B, F, and I, the educational needs, provision, and outcome, and placement are all appealable, directly appealable in terms of the tribunal's jurisdiction to make orders. If the parents are saying, no, you should have named our school, they generally have to show that the local authority school is unsuitable, that it can't meet the child's needs. And then the tribunal will generally name whatever school the parents are requesting, regardless of cost, as long as it is itself suitable. These are obviously cases in which specialist advice will be needed. And helpfully, under the Children and Families Act, all of this applies equally to academies and also to non-maintained and independent schools that are on the Secretary of State's approved list under Section 41. And you can check that out quite quickly with a quick search. If your school that you want is on that list, then the same statutory tests apply. Otherwise, if you want a mainstream independent school, for example, that won't be on the list, you'll be looking at the duty in Section 9 of the Education Act 1996, which is a weaker duty to comply with parental preference for school generally. And then we come on to reviews and reassessments. And so these are quite different things. Under Section 44 of the Act, the Children and Families Act, there's a requirement for an annual review of EHC plans annually, of course. That can be brought forward in appropriate cases, including in an emergency situation. More specific requirements in terms of phase transfer, earlier deadlines for completion of the annual review to allow for tribunal appeals, in effect, in those cases. The duty to carry out the review being on the local authority, not on the school. The school has to facilitate it through the review meeting, but the actual annual review itself is a local authority duty. And whereas a reassessment is really where you go back to the beginning and you start again and gather all the necessary information for the child. And that would only be likely to be necessary where there's been a significant change of circumstance, a new diagnosis, something that's happened that means the child is in a very different place than they were when the previous assessment was done, because otherwise just more general day-to-day changes can be picked up through the annual review process. Now, these timeframes have been relaxed as well through the amendment regulations. And so it is very important that families check that things are being done in the usual way, or if they're not, ask the local authority why they say that the coronavirus exception applies and what's the reason why the timescales have to be relaxed in that particular case. Question around admissions processes for schools in September. Should they also be done virtually? Well, I mean, admissions processes are done virtually in the sense that you make an application online under the admissions, and then the admissions criteria for the particular admissions authority are applied. And in terms of EHC plans, of course, there's the duty to admit the child in Section 43 of the Children and Families Act. So once the school is named in the EHC plan, the school must admit, to the extent that the only real remedy in that situation is for the school to bring judicial review claims against the local authority, which has been done and threatened more often, in fact, but still very rare. So unless they do something like that, the school just has to admit the child or young person. And absolutely, we should be aiming at avoiding any delay in children starting school. It's very concerning if there are going to be delays in terms of children's welfare. Can an EHC plan be seized after the 31st of March? As far as I'm aware, they can be seized at any time. But it's very important to bear in mind that when a plan is ceased, when a local authority ceases to maintain the plan, a parent or a young person can appeal to the tribunal. And while they appeal, the plan has to remain in force, does remain in force as a matter of law and must still be followed. So there's an important protection there, because of course an appeal might take several months, will take several months to get on, possibly longer. And all that time, the local authority has to continue to comply with the plan that was previously, that they were maintaining before they decided to cease to maintain it. Important point about the local offer, because the vast majority of children and young people with SEND will not have an EHC plan. They are supposed to be reserved for those children and young people with significant special educational needs. Whereas the local offer is the generally applicable support that should be available within and outside the local authority's area. And the requirement in section 30 of the Act is to publish information about that, so that parents and young people can see in a transparent way what services and support should be available. And the comments facility on the local offer, I would suggest, is really important, that people use the comments facility that has to be there to provide comments about any inadequate provision, whether that's in terms of the amount or the quality of the provision. Don't use it to make individual case complaints, because that they will not be responded to that way. You have to use the complaints process for complaints. But you can use it to highlight gaps in provision, and then the local authority must respond to those. So that is all that I was going to say for this recap session, for this recording. There's a couple of further questions to deal with. Should local authorities still publish comments every September? The comments requirement is another thing that has been relaxed under the amendment regulations. So if there's a coronavirus related reason, the timescales are relaxed. But again, they can't just say, oh, well, we can't do it. There needs to be a good reason not to do that. And a question that relates to social care. Can local authorities refuse to give direct payments? And if they do give them, say they're for only one specific reason? Well, let me take those in two stages. Can direct payments be refused? Yes, in principle, but it's quite difficult for a local authority to refuse to make direct payments. Again, they would have to be able to explain why not, because there's a strong emphasis on parents having the choice to have their support by way of a direct payment. And there have to be a good reason, a rational reason why the local authority was refusing to do it that way. Can they fetter the use of direct payments? Well, certainly not to say you can only use it for one thing, because why bother making a direct payment in that situation? You may as well just go and commission the service. You can have reasonable limits on the use of direct payments, and in particular, they have to be used to meet eligible needs. They can't be spent on things that are illegal and so on. But the whole emphasis of the scheme is on flexibility and choice and control for the disabled child and the family. And so those limits and all the other administration of the direct payment have to be reasonable. And unfortunately, I think in many areas they aren't. And there's unreasonable burdens placed on families to have direct payments, which potentially need to be challenged. So I think that's everything that we were going to cover again as a recap. I hope this has been helpful. I'm just going to give Sharon a chance to ask any final questions that might need to come through. I will be recapping again some of these points in the second webinar. The second webinar will focus on the issues for disabled young people aged 18 to 25. So of course that group of young people still benefit from, potentially benefit at least from EHC plans. So we'll be looking at that again. But the focus will be also much more on adult social care and adult continuing health care, and the transition process to get into those services as well, and what the Coronavirus Act has done in relation to those issues during the pandemic. So I hope people who are interested in issues for older young people, including those in transition to adulthood, are able to join the second webinar. And just to take one final question, could a school refuse to take a child even though the parents are saying they're struggling to cope at home? Well, I would suggest schools shouldn't refuse in that situation. The guidance is that a risk assessment should be done, and there should be a balancing exercise as to where the child is less at risk. But if a family is struggling to cope, it seems to be perverse, frankly, to say, no, this child can't come to school, when the child going to school might allow the family to keep going. Otherwise, the local authority will end up having to provide services through the Child in Need duties and the Section 1970 Act, and possibly accommodation under Section 20, when they could just let the child go to school, the school could let the child go there. So again, you'd have to look at all the reasons that are given. And as a general point, there are some fairly broad discretions for public bodies and schools and local authorities, but they always have to act reasonably, and that will often usually involve giving reasons that need to stand up and need to make sense and are relevant to the individual case. And blanket rules and blanket policies, or unreasoned decisions, refusals that don't have any reasons, are very likely to be open to challenge, including through judicial review where appropriate, or through the complaints process. But the problem with the complaints process at the moment is that the local government ombudsman isn't taking on any further complaints at the moment during the pandemic. And that really does, I think, emphasise how judicial review is an important remedy. So unless you can appeal to the tribunal, it may well be that your only remedy in practice is to get advice about bringing a judicial review claim. And so my final point is going to be, do please make sure that if you are concerned about the situation your family's in, you get advice as soon as possible. I'll just skip to the end of the slides. Sorry. Just to show you my contact details. If you've got any particular issues arising from the webinar, please do feel free to email me. If you need legal advice, just generally legal advice, that you don't think there's a particularly significant specific issue, then you may want to just look up the list of solicitors on my blog, because if you email me, I'll probably just send you the link to that list. So that's Rights in Reality Solicitors. I can be instructed directly as well, but I can't access legal aid. Only solicitors can get legal aid, not barristers. So anyone who instructs me directly will need to pay my fees privately. So very often people, of course, will need a solicitor instead. If you're more interested in these issues just generally, it'll be lovely to connect with you on Twitter, @SteveBroach. I do tweet about these things all the time. And there's the address for the blog as well. But if you search the term Rights in Reality, and then the thing you're interested in, you'll hopefully find the specific blog posts I've written about most of the issues that I've discussed today. So I hope this has been some help. Again, apologies that we didn't manage to capture the first webinar with all the questions. I think Sharon's done an excellent job of putting lots of the questions to me. And I hope very much to see some of you on the second webinar taking place on Wednesday, the 17th of June as well, or that the recording of that webinar, fingers crossed, is useful for people too.